So this presentation is going to be about the different and various aspects of the criminal justice system. So the first topic that I'm going to go over is the primary components and responsibilities of the criminal justice system. The three main components of the criminal justice system are the police, the correctional agencies, and criminal courts. The police, as I'm sure you already know, enforce the law, investigate crimes, apprehend offenders. They do everything in their power to prevent crime, and in doing so, they maintain order. The second component is correctional agencies. They carry out sentences imposed by the courts, and they provide safe and humane custody and supervision of offenders. So an example is prison. A picture is down to the right. So prisons rehabilitate individuals and they serve their time before they're released back into the community. The third component is criminal courts, and they conduct fair and impartial trials, decide on criminal cases such as guilty or non-guilty, and the three are similar in that they prevent crime, but they also work as a team. They have their own responsibilities, but they work together as well. So the police will arrest offenders. The offenders will go to court and have a trial, and afterwards they will be rehabilitated in correctional facilities. So the second topic includes problems that prevent an effective criminal justice system. So the United States is often described as a melting pot, and that refers to how immigration has resulted in a blend of cultures and ethnicities. A similar term is multiculturalism, which explains how cultures have their own set of norms, values, and routine behaviors. So one prominent issue that affects our criminal justice system is the large influx of undocumented immigrants. There is fear of police authority and distrust of the law, and fear towards the police makes it incredibly hard for the police to do their job. An example would be how African Americans lately during this era are scared of police brutality. So one specific example of that is Philando Castile, who was pulled over by the cops, and when pulled over he informed the cops that he had a gun, and as he was reaching for his license he was shot, and this whole event was captured on camera by his girlfriend, who posted it to Facebook. So I just wanted to gloss over the aspect of police responsibility. It's their job to protect individuals and ensure safety, but it's very difficult for them to do when the public doesn't trust them. So the act of one bad police officer should not outweigh the others. So the next topic that I want to go over is the Uniform Crime Reporting Program, which shows an overview of criminal activity. So it's used to analyze and evaluate existing programs, fashion and design new crime control initiatives, and to plan new laws and crime control legislation. So the Uniform Crime Reporting Program is essential as it is a collection of data statistics that is collected between 18,000 different agencies. So this includes cities, county, university and college, tribal, and state departments. The next topic I want to go over is the past and present of criminal justice in terms of historical precedents and their evolvement. So one major example of this is the juvenile justice system. Juvenile punishment used to be much stricter than it was now. Back in 753 BCE or BC under Roman rule, there was patria potestas and parens patriae. Patria potestas referred to the notion that fathers had absolute control over their children, and parens patriae referred to how the king was allowed to take the place of the parents when dealing with juveniles who violated the law. The 19th century was witness to large-scale immigration. Many children became involved with gangs to survive. So the 19th century set the track for change. In 1823, New York developed a series of houses for refuge to save them from a life of poverty and crime. So these housed these vagrants and runaways. In 1870, Massachusetts enacted a legislation that required separate hearings for juveniles. New York later followed suit and prohibited contact between juvenile and adult offenders. In addition, the Galt court case on juvenile justice resulted in a adult due process rights being afforded to juveniles. So they now have the four basic rights of being notified of charges, having a right to counsel, having a right to confront and cross-examine witnesses, and having the right to protect themselves against self-incrimination. Other essential court cases for juvenile justice includes Breed v. Jones, where there were restrictions placed on being tried as an adult. It stated that any transfers must occur before an adjudicatory meeting or hearing in juvenile court. The next is Thompson v. Oklahoma, which stated that execution under the age is unconstitutional. It violated the 8th and 14th Amendment. In Roper v. Simmons, it was ruled that age is a bar to execution. So those under the age of 18 have not defined their identity yet, so a heinous crime cannot define them. This invalidated the capital punishments of 72 death row inmates across 12 different states. This change and advancement in juvenile justice system gave children the chance to become our future. So the next topic is Peelian Principles, which was created by Sir Robert Paul back in 1829 under the philosophy that the police are the public and the public are the police. It was created to address fear and resistance of public rule, and it forces an ethical community policing policy. So the first principle states that the reason the police exist is to prevent crime and disorder. The second states that public approval for police actions is necessary. They must garner the trust and approval of the public. The third states that voluntary compliance of the public should also be another key factor. The fourth states that police must be loyal to their job and the law. They must always remain impartial and not take any bribes or be swayed by temptation. The fifth states that cooperation is key and the less force that is used, the better. They want to achieve cooperation from the public, not force it or use physical force. The sixth states that the police are the public and the public are the police. The seventh principle states that physical force should be the last alternative. They should try warnings or advice before they raise a hand or any other type of forceful alternative. The eighth states that officers must follow the law to the T and never try to abuse their power. They should never want to have more power than they already do. They're just members of the public who get paid to also protect the public. The ninth states that police effectiveness must be measured through the lack of crime in the community, rather than the number of arrests that are made by officers. So the next topic is offender progression throughout the system. So there are many steps that are taken both before and during a trial. So the first thing that happens after an arrest is the first appearance, and this is when the offender appears before a magistrate or a lower judge. They are notified of their charges. They are notified that they can get a lawyer if needed or wanted, and they are given bail. A first appearance may also include a probable cause hearing, where the judge decides if the arrest was made via probable cause. An example would be if an arrest was made without a warrant. There is also a pre-trial release, which defines the time period between the defendant being released from jail into their court case, and this is often assured via bail, which is often money payments or property. Next, we have grand juries, where there are 23 individuals selected to hear evidence. They then vote on an indictment, such as innocent or not innocent. And then there is a preliminary hearing, which actually is synonymous with grand juries. They allow offenders to challenge the charges made against them. Then there is the arraignment and the plea. So during the arraignment, the offender has to plead either guilty, non-guilty, or no contest. There's often the plea bargain, which is an agreement made by the defender, the prosecutor, and the courts. So next is the courtroom procedures. It begins with trial initiation, which is based on Speedy Trial Act. And this just works to aid in preventing people who are in jail who can't make bail to be stuck in jail for long periods of time until their trial starts. Then there's the jury selection, which is based upon the Sixth Amendment, which offers the right for an impartial jury. And voir dire is where both sides will question the potential jurors. Then there is the opening statement, which is made by both the prosecution and the defense. Facts will be presented, and then at this point, witnesses will speak. Then there is the closing arguments, where the case is summarized to the judge. They review and analyze the evidence, and they try to persuade the jury towards guilty or non-guilty. Then there's judges charged to a jury, where the judge instructs the jury to deliberate evidence, where they go in a room and they contemplate. Then a verdict is given, either guilty or not guilty. And that is the end of this presentation. Thank you.